I was involved in an automobile accident, and my lawyer told me not to post anything on social media about my accident. Does it really matter? Hi, I'm Paul Hernandez, attorney at Kalfas and Ackman, litigating cases across Virginia and North Carolina. Client social media accounts are the number one way insurance companies find out about the client's character, credibility, and behavior. As soon as a person makes a claim with an insurance company, they have their companies scour through that person's social media footprint to find ways to minimize their insurance exposure. Think about it. Most people post everything about their lives on social media: where they live, their birthday, their family members, their friends, their likes, their dislikes, their political beliefs, their vacations, what they like to drink and how much, their taste in humor, their activities like riding roller coasters, their abilities in sports, and so much more. Every one of these things can affect a personal injury case. Let me give you a couple of examples of how your social media footprint can destroy your personal injury case. Let's say you were in an automobile accident last spring and your neck and your back were hurt. You received medical treatment to heal your back and neck. However, your family vacation was interrupted with your treatment. You went to Florida and visited several amusement parks. You posted several photos of you riding roller coasters, zip lining, and going tubing behind a boat. All of these are physical activities that one would think would be hard to perform if their back was hurt. When you get back from your vacation, you pick up where you left off with your medical treatment. The insurance company will say your back was not hurt in the wreck, but from all the various activities you engaged in during your family vacation. Your credibility is shot if you claim you were suffering from back pain from the accident when you went on your vacation. How about when an insurance company looks at your social media feed and every picture of you has you holding or chugging an alcoholic beverage? That's not going to go over very well. If there was a question about whether you were under the influence of alcohol when you slipped and fell in that convenience store in front of the beer cooler, how would you like for evidence to be presented at your trial of you at a political rally? It doesn't matter for what party or candidate the political rally was for. It is guaranteed that 50% of the public is not going to like that political party or candidate and discount your case accordingly. It seems unfair. However, nobody would have known about this information if it was not for you plastering it all over social media. Many people act differently in their image on social media than their real life, as well as how they act in court. Let me share with you what happened to one of my clients' cases after the insurance company took screenshots of my client's social media feeds. My client was a 19-year-old male who was injured in a bus accident. He was on his way back home from a relative's house 3 states away when the bus driver fell asleep, crashed the bus into a ditch. There was no question that my client received serious injuries to his wrist and his shoulder. As a matter of fact, he incurred over $35,000 in medical bills just to treat him for his injuries. My client needed more treatment. However, he was unable to get the treatment because his health insurance had run out and he did not have the money to get the medical treatment. I was explaining that to the insurance adjuster when the adjuster challenged me in my assertion that the client did not have the money. The adjuster emailed me screenshot after screenshot of my client's social media posts. The images showed my client holding up gang symbols with his hands, stacks of currency, and what appeared to be packages of drugs and alcoholic beverages in every image. I immediately contacted my client and asked him about the images. He confirmed that the images were of him, that he posted them. However, he explained that everything in the images were fake. He was just trying to give the image that he was a bad boy. Either way, you do not want to be explaining that to a jury of adults who do not take kindly to those images. Needless to say, we settled that case for a lot less than what we should have settled the case for if those images did not appear. I need to make sure you also understand something about the images like that on your social media feed. You see, my client said that he could delete them and deny that they were even of him. Then the bus company would have to prove that those pictures were of him. I explained to him that that was a bad idea and it would be unethical for me to be part of that farce knowing that it was untrue. So if you want to put yourself in the best position to have great success in pursuing your personal injury case, do not post controversial posts on your social media and always keep your social media private so only friends can see your posts. It will make it harder for the insurance companies to find your social media posts. If you have any questions concerning social media posts or personal injury claims at all, call me, Paul Hernandez, attorney at Kalfas and Ackman. I answer questions like this every day. And by the way, if you enjoyed this video, click the subscribe button below. That way you'll be notified every time we post a new informative video. I'm Paul Hernandez, litigation attorney at Kalfas and Ackman. Thanks for watching.
Thank you.